So California is now begging Judge Benitez to void his prior order and push the California magazine ban case back out until March of next year. So let's talk about this. But real quick before we jump into this video, if you believe California's ban on so-called large capacity magazines is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year and employs roughly 400 people within the US. Kershaw produces a broad range of knives to meet everyone's needs. From a $20 Walmart knife all the way to a $200 US made automatic knife, Kershaw has your needs covered. One of Kershaw's top goals is to provide a value-packed product backed by a limited lifetime warranty, regardless of your current budget. So I highly recommend Kershaw Knives. I carry one of their knives every single day for my EDC. And right now, if you go to their website and you use the code SCHOLAR20, you can get 20% off site-wide, plus free shipping on orders over $100. And that offer lasts all the way until December 1st. So go check out Kershaw Knives by going to kershawknives.youknowwhat, and thank you again to Kershaw Knives for sponsoring this video. So like I said in the intro, the state of California is now asking Judge Benitez to change his mind in the Duncan v. Bonta California magazine ban case. The last time we talked about this case, I told you that Judge Benitez issued a new order after the Ninth Circuit en banc panel remanded the case back down to him for reconsideration in light of New York State Rifle and Pistol Association v. Bruin. In that order, Judge Benitez gave California 45 days to file a supplemental brief with arguments on how Bruin impacts this case, and the state essentially has to put forward evidence on what history and tradition supports this state magazine ban. The result of this order made it so that both parties would need to file all of their arguments, all of their briefs before the end of this year, and this case would be resolved before the end of this year. However, California is now pleading with Judge Benitez to change his mind and give the state of California more time to file all those papers, those briefs, and also to find more evidence to support their magazine ban. Now, for those not aware, Duncan v. Bonta involves the possession and purchase of so-called large capacity magazines within the state of California. California Penal Code Section 32310 bans the buying, selling, and possession of magazines that hold more than 10 rounds. This law was challenged, and a district court judge, Roger T. Benitez, or St. Benitez as he's known in California, issued a ruling that found that this law in the state of California was indeed a violation of the Second Amendment. Well, the state of California obviously didn't like that. They didn't like that they lost, so they appealed that decision up to the Ninth Circuit. Because of that, Judge Benitez issued a stay on part of his judgment, but left part of it in effect to protect those who purchased Freedom Week magazines. Then the case made its way through the Ninth Circuit. There was a 3-judge panel review at the Ninth Circuit level, and that 3-judge panel upheld the decision of Judge Benitez. Then the en banc panel reviewed that decision by the 3-judge panel, and ultimately what they did is they sided with the state of California, and then the case made its way up to the Supreme Court. After the Supreme Court ruled in New York State Rifle and Pistol Association v. Bruin, the Supreme Court granted, vacated, and then remanded the Duncan case back down to the Ninth Circuit en banc panel to reconsider the case in light of their decision in Bruin. Then the state of California pushed the en banc panel to vacate the Judge Benitez judgment and his prior ruling on the summary judgment, and to also have the case remanded back down to him for the case to be reconsidered in light of Bruin. And ultimately, the Ninth Circuit en banc panel did do that. They agreed with the state of California and sent this case back down to Judge Benitez. Once Judge Benitez got control of this case, he continued the preliminary injunction protection on the possession of pre-ban and also Freedom Week magazines. If you're interested in that topic, you can watch one of my prior videos where I discussed that issue. But in that same order, he also set the case to be resolved by the end of this year. Well, the state of California just recently filed a new motion, and essentially they are asking Judge Benitez to reconsider his order and to give the state of California more time. In this motion, California argues that good cause exists to grant the requested relief to modify the briefing schedule set forth in this court's order, as it affects a clear error and manifests injustice on the parties. They go on to state that the weighty Second Amendment issues raised by plaintiffs should be resolved based on a historical record compiled by the parties, which will require expert discovery to prepare. Plaintiffs' claims are thus ill-suited for resolution based solely on the court's truncated briefing schedule, which provides the Attorney General scant opportunity to engage in the discovery necessary to compile the record. Preparing a record that will discern these historical traditions will involve original historical research, an unpredictable, labor-intensive, and time-consuming process, albeit a necessary one. Here, the language California is using to question the original schedule in this case is really interesting. It's almost like they're calling out Judge Benitez, and they say for his truncated scheduling, and that they will not have enough time as required under law to actually put forward the evidence that's required. And to me, the type of language and the tone that they're using in this motion, I don't think it's a good strategy. They go on to further argue that review and interpretation of source materials also requires historical expertise if such work is to be done correctly. Although attorneys and judges are accustomed to performing textual analysis of laws, historical scholars are better situated to interpret 18th and 19th century statutes within the broader historical context, referencing what events or circumstances contributed to a law's enactment or the law's enforcement history. Accordingly, a complete and accurate supplemental record must include expert testimony. This analysis should not be rushed. Although the Attorney General cannot provide a precise estimate of how much time would be needed to conduct a thorough identification and review of source materials, at a general level, a historian conducting original research on primary source materials would fairly expect to conduct many hours of work to yield several sentences of written historical analysis. As a practical matter, most qualified historians would be unable to devote themselves to this endeavor full-time on account of other research, teaching, and professional obligations. Now, I want to stop right here because this is a similar argument that the state of California made in the Miller v. Bonta or Miller v. Becerra California ban on so-called assault weapons, and that argument was actually rejected by Judge Benitez. However, there is this additional wrinkle that they are stating that judges are not fit for this type of analysis, this type of historical analysis, and that they actually need a historian, an expert, to look at this type of stuff. I think this is California calling back to Judge Benitez and his denial of that original request in Miller v. Bonta, where he said that judges often review historical evidence, they review case law, and that they are well suited to look at the history themselves, and that there is not a need for historians or professors to come up with this type of evidence. So I think this is kind of California throwing a really weird jab at Judge Benitez and his prior language and ruling in the Miller case. Again, I don't think it's a good strategy, and I think it's kind of these weird small jabs that are happening in this motion that I don't think that Judge Benitez will like. And based on all of that, California puts forward a proposed schedule in this motion that would result in March 17th, 2023 being the last day for California to file their reply. This would result in maybe next year, March, maybe April, being the potential end date for this case, the Duncan v. Bonta California magazine ban case. So California is simply trying to buy themselves more time. And again, they're filing this motion after Judge Benitez has already issued an order setting what he said is going to be the schedule to have this case resolved. What is interesting about this motion is the state of California tried a similar thing, like I said, in the Miller case. In that case, Judge Benitez denied that request to push this case out to next year. When Duncan was remanded, Judge Benitez anticipated that California was likely going to make these similar arguments that they did in the Miller case, so he went out of his way in the initial order to set this case to be resolved by December. So he went out of his way to go ahead and set the schedule right then and there at the initial order. That was him pretty much, in my eyes, preemptively telling California, no, don't even try to prolong this case. Don't even put forward those arguments, and don't put forward any motions or anything like this trying to argue that this case needs to be dragged out until next year. That was him, in my eyes, telling them or shutting down this type of argument at the very beginning. But I guess California did not get the message, and instead they decided to file this motion and are telling Judge Benitez he made a clear error in his original order and that he should change it and give them even more time. So it's going to be really interesting to see what Judge Benitez ultimately says in response to this motion. Like I said, if we get any more updates, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impact this channel, and help me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.